yesterday if I missed litigating, and I actually said, I don't miss doing depositions. And I know you've been busy at that, Steve.
Yeah, it's funny, I'm just turned 58 last week, and it's starting to wear on me.
Yes.
Yeah, I need to find some other new gig, maybe some transactional stuff that, some of you guys do.
Or just some good young associates to turn it over to, Stephen.
Get into the exciting world of commercial paper, there you go.
That would be fun.
Mr. Chairman, before you get started, I just point out that the public can't see the members who are on the teleconference.
Well, thank you for pointing that out.
Will it be okay if I move up here, or?
You cannot move up here, but let me see what we can do.
Okay, and I'd also like to point out that the agenda materials have not been made available to the public.
Well, thank you for pointing that out.
Yes, sir.
Who are you with, Mr. Hunter?
The public?
Where do you work? Do you work?
Yes, sir, I do.
Oh, are you a reporter? I'm just
No, sir. Just a concerned member of the public.
a member of the public.
Yes, sir.
Okay, good to have you here. Bobby White.
Nice to meet you.
Are you actually logging in as a guest too?
No, ma'am, I'm not.
Here's the copy.
Okay, thank you so much.
Hey, Sonia. Can you hear us? Morning, Sonia. And Nick?
Good morning, can you hear me?
Yes.
Yes.
Okay, yeah, I can hear y'all, but I can't see you.
I think we still haven't
We're
shared it.
gonna
yet.
fix that. That's been pointed out to us.
Okay.
Morning, can everybody hear me?
Yeah, good morning,
Yes,
Nick.
Good morning, Nick.
Nick, you didn't wanna make the nice drive down from Corinth this morning? Uh-oh.
Well, I was there last night, I came back,
Oh, were you?
I was there in Jackson yesterday, I came back home to watch the middle school baseball game.
There you go. Important stuff.
Yeah, that's right.
So I'm going to call this meeting, we're gonna call this meeting to order, and to start it off, Sam, can I ask you to open us in prayer this morning?
Father, we give you thanks for another day. We thank you for the opportunities that we're presented with each and every day. We pray that you would give us wisdom to address all the issues that come before us today, and discernment, Father, and do what is in your will and in accordance with the obligations that have been placed upon us. We ask these things in your name. Amen.
Thank you, Sam. All right. First thing on the agenda is the minutes from our last meeting. Everybody's had a chance to look at those and see those. Were there any comments or any questions or any corrections? Do I have a motion regarding the minutes?
Motion to approve, Mr. Chair.
Second.
We have a motion and a second. Is there any discussion? All in favor indicate by saying aye.
Aye.
All opposed, no. And the ayes have it. And the minutes are approved. The next one on item B, and this is our monthly expenditures. Tom, I'll turn that over to you.
Mr. Chairman, today is the first of the month, and so, I don't have, an expenditure report right now. I can send that to y'all later, but it's been like every other month. We've, spending's been, what we expected. We haven't overspent or underspent.
Good deal. I'll move on then to item C, the legislative report. Anything we need to know about from the legislature?
Mr. Chairman, this is I think a pretty long report and a very interesting report. I hope y'all had a chance to look at some of these bills. I've been trying to get some information about a couple of these bills, particularly the ones at the top that would directly affect, the commission. And I haven't been able to find out any information about those. If you look at the deadline list, though, we've got, committee deadline coming up soon. I think a lot of these bills, traditionally, most of the bills, of course, don't pass the committee deadline, so, we'll see what happens. The campaign finance bills, if you've had a little chance to look at those, they're very similar. I have been told that the first bill, Senate Bill 2575, is probably the one that is most likely to pass. That bill and the third one, House Bill 1504, are very, very similar. The middle one, Senate Bill 2585, I have been told is the one that Secretary of State's office prefers. It sort of has everything that they want in it, but the other two bills are very similar. All those bills mostly take the Ethics Commission out of the campaign finance enforcement process to the extent we're in it at all. They would send the fine assessment authority back to the Secretary of State's office. One of them would allow an appellate procedure that would come through the Ethics Commission, so if the Secretary of State finds somebody, they can appeal it to the Ethics Commission. The others have just a straight appellate procedure. It's a circuit court. And those are the main differences in those bills. So there's also one other difference about auditing campaign committees. There's a provision that would allow the Secretary of State to request the auditor, the state auditor, to audit a committee unless the state auditor himself is connected somehow to that committee. Then that authority would switch to the Ethics Commission. The Ethics Commission would have to hire a CPA to go do that. I don't know how the Ethics Commission would pay for that.
I would say maybe some financial constraints on that.
Yeah, but I think that provision is in the middle bill, not the other two bills, so it sounds like that there's already some opposition to that. So we'll just see, we'll have to wait and see what pans out, but any of those bills would mostly at least get us out of the campaign finance function.
Tom, on the one that would require hiring somebody, just need burn the whole, that was pretty good, because if that passes, we would get the appropriation.
Exactly. As I said, I've been told that was not likely to pass, and I think that's the only difference really between that one and the other two, or the main difference. But we'll see. We'll have the committee deadline soon, and if that bill proceeds, then yeah, then I gotta go talk to somebody about, how we're gonna pay for that. The public records bills, the most important ones are the ones at the top, the ones that would extend the repealer. I don't think anybody fully understands how a repealer got stuck into the Public Records Act. It shouldn't be in there. There was a provision inserted into that section a number of years ago that had to do with, sealed bids and when they can be accessed through public records requests. And I think the intention of the repealer was just to repeal that one provision. But instead, it's a repealer on that whole section, which is the guts of the Public Records Act. So I wish they would just remove the repealer rather than extending it. Or maybe if somebody wants a repealer on that, that procurement provision, take it out and put it somewhere else. And put a repealer on it in that section. But I'll be watching those bills very closely, as will a lot of other people. Anybody that cares about Public Records Act is gonna be keeping an eye on that to make sure that at least gets extended. Do you have any questions about any of these other bills? Those are the highlights, I would say.
Tom, this is Stephen. I have a quick question since I haven't looked at any of these bills. The very first one about public official appointments and about Senate confirmation for Ethics Commission members. What other bodies are included with that are being added to a potential requirement for Senate confirmation?
Stephen, I honestly don't remember. There were a lot of other bodies, though. It looked to me like somebody went through the code and gathered up all the state boards and commissions that don't require Senate confirmation and just put those into one bill. If you notice, we're in section section 46. It's a very long bill with a lot of boards and commissions in there. This is certainly not something that was targeted at the Ethics Commission. We're just one of the agencies that got put into this, but it would require Senate confirmation for Ethics Commission members. It would start, I think, in 2028, and it has an odd reconstitution provision. It says the commission is hereby reconstituted. It doesn't change the number of members, it doesn't change who appoints them, but it said 5 would be appointed in 2028, I think, and 3 appointed the next year. But it doesn't say which 5 and which 3 or who would appoint them or anything like that. So if that thing starts going somewhere, it's sort of like the funding in the other bill. I have to go talk to somebody and ask them to clarify what they mean by that.
Okay.
They're gonna stay pretty busy if they're gonna have Senate confirmation on all these boards and committees.
Yep, they're taking on a lot of work.
Any other questions? Thanks for that report, Tom. All right, let's move on to item D, our annual report.
Mr. Chairman, this is another list from the Secretary of State's Office of Campaign Finance Delinquencies. This is a list of folks who were either late or didn't file their 2023 annual report, which was due January 31st, 2024. I checked the Secretary of State's office about this because there are some people on here who I remember who used to be in office and who haven't been in office for a long time. And they confirmed for me that there's a lot of folks on here just simply because they never filed a termination report. And if you don't file a termination report with the Secretary of State's office, then you have to at least file an annual report every year. And so a lot of these folks are people who just have not done that. And we've already edited our normal fine notice a little bit to tell folks, and we got this language from the Secretary of State's office. So Secretary of State's office has already sent a letter to all these people that said, hey, if you don't hurry up and file, you're gonna be fined. If you want to terminate your filing obligations, then you need to file a termination report with us. So we just copied and pasted that same sentence from their letter to remind these folks, hey, this is gonna keep happening every year if you don't file a termination report with the Secretary of State's office. So hopefully that will prompt some of these folks to go in and wrap this up so they don't show up on these lists anymore. But it's obviously a very long list, and that's why there's a lot of folks that just forgotten to file their annual report. So we're just simply asking that the commission approve sending out notices to everybody on this list.
Do we have a motion?
Hey, Tom, one
Hey, Nick.
question. I see if you don't happen to have passed away, what happens in those situations? I'm just curious.
I don't know. There was, I remember one incident with a former legislator who was incapacitated. And I think that person's spouse filed a termination report with the Secretary of State's office, but I'm not sure. Again, you know, this is one of the symptoms of the problems with the campaign finance law and with us being injected into it several years ago, is we don't really have any right or authority to ask those kind of questions officially. If the Secretary of State puts them on the list, we have to send them a notice. If the Secretary of State takes them off the list, we have to rescind the notice. There's one like this on the agenda today. So the law puts us in a position where we don't really know how to answer those questions and don't have any authority to figure it out because we're not the filing entity. That's the Secretary of State's office. Now, the reason I can't answer it is because I can't speak to the Secretary of State's office. You know, maybe if somebody notified them that the person was deceased, maybe they would take the person off the list. But I don't know what their procedure is for that. It's a good question, and I'm sorry I don't know the answer, but it would have to go to the other agency. You know, again, this is just a symptom of what happens, result of what happens when two separate agencies are put into the same part of the same process. We're really just dependent on them, and we can't speak for them. It's a good example of how messed up it is.
Any other questions, comments? We have a motion regarding sending out these letters.
So moved, Mr. Chair.
There's a motion to send out the letters. A second?
Second.
And a second. Any other discussion? All in favor indicate by saying aye.
Aye.
Those opposed, no. The ayes have it, it's unanimous. Now, item E, under campaign finance waiver request.
Mr. Chairman, this waiver was received by a candidate for legislature who essentially says that her filing with the Secretary of State's office was delayed because of the winter weather back in January. The governor declared a state of emergency on January 14th, which I think has some legal significance. My recollection is that the winter weather in most places in Mississippi, at least in central Mississippi, didn't hit until a couple days after that. The problem is that the report was due on January 10th, 4 days before the governor even declared the emergency. So I don't see how the winter weather constitutes a unforeseeable mitigating circumstances when it didn't happen until after the deadline. And so I'm recommending the commission deny this request.
If I remember right, one of the requests says, I was gearing up for the winter weather.
It does, and it's the same recommendation.
All right, we have the recommendation from the staff. Is there any discussion or any questions? Do we have a motion regarding the recommendation?
So moved.
Move that it be accepted as made. Is there a second?
Second.
Second.
There is a second. All in favor indicate by saying aye.
Aye.
All opposed, no. And it passes unanimously. Item F.
Mr. Chairman, this is this item F is a request from a political committee. They don't really plead unforeseeable mitigating circumstances either. This one is a little confusing because it was initially, they sent their request to the Secretary of State's office, and the Secretary of State's office forwarded over here to us. Then sometime after that, the committee sent us an email directly, and it basically said the same thing, that they just forgot. And of course, we don't have the discretion to waive a fine just simply because somebody forgot to file their annual report. It doesn't involve unforeseeable mitigating circumstances such as the health of the candidate, and so I'm recommending that this request be denied as well.
We have the recommendation from the staff. Any discussion? Do we have a motion regarding the recommendation?
Motion to approve the recommendation.
Second?
Second.
And we have a second. All in favor indicate by saying aye.
Aye.
All opposed, no. And the ayes have it. It's unanimous. Item G.
Mr. Chairman, item G is another waiver based on the winter weather. Again, the governor's declaration was January 14th, but the deadline for the report was January 10th. So my recommendation is that the request be denied. Timmy, is Nick still on?
I'm here.
Okay.
There he is.
Oh, there you
Sorry, we couldn't.
You weren't on the screen, I thought we'd lost you there for a minute.
You're very important today, Nick.
Everybody's important. If we lose
Everybody's
anybody,
very
we lose our
important.
quorum.
All right, we have the recommendation from the staff on this. Is there a second? Motion?
Motion to approve.
A second?
Second.
And we have a second. All in favor indicate by saying aye.
Aye.
All opposed, no. And that passes unanimously. Item H.
Mr. Chairman, item H is another, waiver request from a committee. I'm sorry, this is not really from the committee, this is from the Secretary of State's office. This is a committee that we sent a fine notice to, last time, because they were placed on the list by the Secretary of State's office. They then went back to the Secretary of State's office and said, we think y'all made a mistake. The Secretary of State's office has now come back to us and reported that this committee was placed on the list in error and that this organization should not have been fined. But because the commission has already issued this fine, I think the commission would have to vote to rescind it, and so that's what I'm recommending. Since the Secretary of State's office has said this committee was placed on the list in error, the commission should rescind the fine and notify the committee in writing.
We have a recommendation that we rescind this fine. Is there a motion on that?
I move we rescind.
Is there a second?
Second.
A motion and a second. All in favor indicate by saying aye.
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 Those opposed, no. The ayes have it, and that passes unanimously. We'll move on to public records cases. Item I.
What's going on?
The pages aren't showing.
What?
The pages are not showing. It's like they're blank.
Should close it for you, but y'all bear with us just a second, we have a problem with the computer here. It's frozen.
Technology is great when it works. Hey, if you don't fix it, I can't fix it.
Freeze up.
Maybe we can get the legislature to approach us, a full-time IT guy or something.
That's what we're gonna need. When I was at my appropriation hearing in the House, they were putting that on Zoom, and they had a full-time guy there running it. They didn't do anything else. It's really hard to do this when you're doing something else. Yeah. We were having trouble yesterday, which I think was because of this computer. All right, what page? 50 something. I got share that, right, that was share. Can everybody on Zoom see the document on the screen? Sonia, you got it?
Yes,
Okay,
yes,
sorry about that.
all right.
You're doing a very professional at this, you and Tammy both, you know.
Well, it takes two, and we got other stuff to do too, so.
Item I.
Okay, good morning, commissioners. So this is, public records case R-22-053, Lowry versus the Wayne County School District. I'm recommending that the commission, dismiss this, complaint. Mr. Lowry requested some salary information from the school district, which it provided. Mr. Lowry, his complaint essentially was he did not receive what he had requested. From reviewing the request and the documents produced in this case, Mr. Lowry received public records specifically reflecting the information that he requested. His, complaint, stated that his that the information he was seeking was slightly different than what he actually requested. So this is simply a case understanding because you, maybe made an error in, the manner in which you were requesting the documents in terms of labeling what you were requesting. In his complaint, he said he was seeking the salary and benefits for each person employed by the school district without the employee's name, but he had, in his request specifically asked for salaries and benefits by position, so they gave him a schedule. And then he also asked for supplements and additional compensation, for which they also provided him a schedule. So accordingly, the district did not violate the Public Records Act.
Sonia, as I understand it, he got what he asked for, but that's not what he wanted.
That's correct.
All right, we have the recommendation, from the staff. Is there any questions or comments? Do we have a motion regarding?
Motion to approve staff recommendation.
Do we have a second?
Second.
We have a motion and a second. Any other discussion? All in favor indicate by saying aye.
Aye.
And opposed, no. The ayes have it, and that passes unanimous. Sonia, item J.
Item J, this is case R-23-001, Johnson versus the George County School District. In this case, I'm recommending that the commission find that the school district violated the Public Records Act by attempting to impose fees that exceeded the actual costs, as well as preventing the complainant from photographing public records. The commission should order the school district to revise its public records policy to comport with the Public Records Act. So in this case, Mr. Johnson was a reporter. He may still be a reporter. And over the course of 3 public records requests, had requested copies of employee contracts, a legal service agreement, and some board minutes. For the first request, the board attempted to charge him $211 and some change for 7 pages. They revised it a couple times, ultimately reducing it to, I believe, $50.84 for 19 pages. The second request, they provided a quote for $137.65, while stating that that charge would not include a $250 an hour charge for any legal review for 38 pages. And finally, for the board minutes for 9 meetings, he was quoted $381.40 for 700 pages. The district's policy actually changed twice since the time that Mr. Johnson filed his original public records requests. At the time of his request, the policy stated 30 cents per page plus $1 minimum search fee, $5 for staff time. This policy alternately went to a $10 copy charge plus anywhere between $25 and $100 per hour for search fees. And the district in its response specifically said that they charge the 25 cents per copy includes costs for ink, paper, use of the copy machine, and the $10 for running the copy machine was less than the labor of the executive, or the hourly rate of the executive secretary, who would most likely be running the copy machine at the time. So I did ask the school district for some additional information with regard to that 25 cents, and they actually were able to break down the per page charge for me pretty well, and it ended up coming out to about 2 cents a page. So in this case, as a Public Records Act states, a public body can never charge more than the actual cost of providing public records. the district submitted information to the commission that their actual per page copy cost, including labor, was about 2 cents a page. So their attempt to charge 25 or 30 cents a page is excessive and violates the Public Records Act. Additionally, their attempt to charge a separate hourly rate for labor to run the copy machine violates the Public Records Act because that charge was already included in their per page cost. The charge to search for the documents must be at the lowest employee rate competent to search for documents. So if they're using the executive secretary's rate, they can't round up to $25. It must be at the $24.40 that they quoted, or possibly less if there's somebody else competent to run that search for a lower rate. And finally, the time that the district was estimating to search for records just seemed excessive. To state that they were going to, I believe it was 5 hours to search for several employee contracts, another, and that was on the second request, and that was just for employee contracts. They were estimating it would take 2 hours to search for board minutes. If they're well organized, it shouldn't take that long. So I've included a statement in there that the time to search was excessive and should not include the time to copy records. And finally, a flat rate deposit is not a reasonable estimate because it's not calculated to reimburse for actual expenses. And then the second issue was that the photographing of public records, many public bodies seem to be reluctant to let members of the public inspect public records and then use their phone to make copies without collecting a fee for those copies. There was a very good AG opinion which discussed this, and unless there are other circumstances such as fragility of the public records or where you're saying don't unstaple the records, you really can't tell them you can't use your phone to photograph the records. I mean, if you're bringing in your own 2-ton scanning machine and you don't have the space to allow a member of the public to use that machine in your office, that's one thing. But if they're simply taking their phone and taking pictures of documents, there's no basis in the Public Records Act to restrict that or to charge copies for those pictures that the members of the public is taking.
All right, we have the recommendation from the staff regarding this case. Is there any questions or discussion?
I just had one question, not really with respect to the details of this, but one of our recommendations is that we direct the board to revise its policy. Do we have that authority to direct them to advise the policy, or should we simply say we advise them that they should revise their policy so as not to repeat this problem in the future?
We've sort of done both. Where we felt that somebody's rule was not sufficient, we've advised them to adopt our model rules, but where their rule was just not legal, we've ordered them to change it. And that's under the part of the statute says we have the authority to order boards to take any reasonable action necessary to comply with the law. We've not been challenged on it.
Okay. That answers my question. I just didn't know the answer to it, so that's the reason I was asking the question.
That's a good question.
And first of all, I want to commend Sonia for doing a great job on this case. She always does, but she's really good with details, and this was a very detailed case. And I get a lot of questions about copy cost, And it doesn't seem like a big deal because we're talking about pennies, but those pennies add up to a lot of dollars when you're, making a lot of copies. I had some folks tell me at a training session a while back that they thought 15 cents a page is too low. And after this case, we don't deal with copies much. Nowadays, most everybody wants everything electronically. But we went and looked at our own copy cost, and it was higher than theirs, considerably higher than what they came up with that this district did. One of the things that was asked of me in this training session a while back was, it was a large municipality. They had multiple copy contracts with different companies, and they had different costs on different copiers from different companies, and some of them included paper and toner and some of them didn't. And I just said, look, the law says you can only charge your actual cost, and we've not said you can't charge more than 15 cents a page. We've just said that if it's more than that, you gotta show your math, you gotta explain why it costs more. So I think this case does a really good job of dealing with the details in this case, and also leaving room for higher costs if they're actual costs.
And certainly not our responsibility to go in and I think try to correct their error, but I would be willing to bet you there is absolutely no way in the world that their copy cost is 2 cents per page, based on everything that's included.
Yeah.
You just can't do it, couldn't do it.
I would have thought that was about right, but after looking at our costs, and they were a lot higher. Yeah, so we made it, our 15 cents a page ceiling is old, and that's what I've been told recently, and I was doubtful of that until I saw this and we looked at our own costs, and I realized we may need to go back and look at that again, resurvey that, and see if that cost is.
So much I was driven these days by agreements with where you rent the equipment and the copier, and all those costs are built into that over a period of time, and it drives the cost up.
That's what we had to do, because we don't have the money to buy a copier if it breaks. We have to lease it, and that changes the per page cost when you do that.
Do we have a motion regarding the staff's recommendation in this case?
I move we adopt staff's recommendation.
Do I have a second?
Second.
Any other discussion? All in favor indicate by saying aye.
Aye.
All opposed, no. The ayes have it, and that'll pass unanimously. All right, item K. Sonia?
Yes, sir. So item K is R-23006, our friend Mr. Lowry again, against the Wayne County School District. This time, he is complaining that, he was being charged excessive fees, and my recommendation is that the, Ethics Commission, does find that he violated, that the district violated the Public Records Act by attempting to impose, fees exceeding actual costs. And again, to order the district to revise its, public records policy to comport with the Public Records Act. I do also, I think I missed this earlier, and I would, like to ask the commission to, revise or to allow for a slight revision in my, recommendation to, approve a refund. I do believe Mr. Lowry paid the fee, and so if it is excessive, that the, school board refund the portion that was excessive. So Mr. Lowry requested some salary and grant information, and the district provided him a single-page summary and charged him $135. They said it was 2 pages and 2 hours of work to compile the information for $65 an hour, which was the district business manager's rate. So first, the dollar per page, they provided that without providing any support for that. So without supporting that cost, there's the assumption that is excessive, since it exceeds the 15 cent per page cost approved by the commission, as a default cost. And in this case, the district created a new document, which it may do so in its discretion, but it's not required to do so. But it cannot charge its time spent to create that new record. If the parties had agreed that this was, the best way to do things and it would reduce the cost for Mr. Lowry, they could have suggested that to him. But if they unilaterally decide to create a new record, they can't charge for the compilation of that record. They can only charge for the search time for that record, which wouldn't be 2 hours. So that time, attempting to charge that time is excessive. And finally, in reviewing the district's policy itself, they also have a $25 flat fee for records requests, which violates the Public Records Act. So again, I'm requesting that the commission approve also an amendment to the preliminary report and recommendation, simply to point 3.3 to provide Mr. Lowry a revised cost estimate and refund if necessary for providing the requested records.
All right, Sonia, do we know the amount that he paid?
Yes, he paid $132. That was what the quote was, and he did receive that document, so I believe that he paid it. I believe in the file he shows a receipt of payment.
So he paid $132, but that was an overpayment, and so we're gonna order them to refund the overpayment, but that's not the entire $132. Is that right?
I mean, it would be $132 less 15 cents, I guess.
How much did they overcharge him? That's what I'm asking.
Well, they provided him one page, so the one page should be 15 cents. After creating the document, there should be no time spent searching for the document that they created, so I'm not really seeing any labor costs there.
Oh, so you're saying they should have charged him 15 cents instead of $132?
Yes.
Okay.
Why wouldn't there be labor costs? Somebody had to look at it and come up with the information to prepare that one page.
That's correct, but that's not part of what the Public Records Act allows recovery for. They instead of talking to the requester and asking him if he would agree to pay for that, they unilaterally just created a document. And you're not ever required to create a document, but they decided to create a document. And once that document is created, you can charge for the search time. But I think pretty logically, once you've created the document, it's on your computer, there's no time to search for it. I mean,
They just didn't handle this right, correct? What they should have done is said, we don't have what you're asking for. We can either go compile a whole bunch of stuff and redact it and give you that, or we can create a new document at a lesser cost. Which one do you want to do? Is that the way they should have approached it?
Right, and it could have been that the compiling all of these documents for the, I'm trying to remember, the salary and grant information could have been less than 2 hours of work. I don't know that the district's business manager would be responsible for searching for all of those documents. I don't know if there actually would be redaction that would be necessary. I don't really know what it would have taken to compile the documents that he had requested. All I know is that the district charged ahead and created a document and then tried to charge Mr. Lowry for the creation of that document.
So we're saying that they can't charge for whatever effort went into providing this document because they didn't have the initial agreement with him to do that. Had they gone the other route and simply produced redacted documents and charged for that time, then we would not object to that, correct?
That's correct.
So we're basically saying, you never have to create a document, but if you do, you can't charge for it unless the requester agrees?
I mean, the Public Records Act doesn't allow you to charge for creating documents for a requester. It just.
Yeah.
I don't
Because
see
it
that
doesn't
being
require
fair.
you to create records,
Well, you're not required to, but that doesn't mean that you can't.
that you can't charge for, that you,
That
yes.
You can't create. You
We've
can
said that in our
create
model
whatever you
rules,
want
we've said that in a number of cases, you
You're
don't
not
have, you
required.
never have to create a record, but you can if you want to.
Yes, it seems to me, I kinda agree with Sam, the record was created pursuant to this request, so it wasn't already there,
Correct.
a created document. So someone had to compile and create that document, and it took some labor to do that, other than shooting a copy of the one page. So, I'm a little bit, concerned about just charging 15 or doing away with the whole charge. Cause there's some cost there, I guess the requester could have objected to it once he received it, said, no, this isn't what I asked for. But did he object to the created document? Do you know?
No, he didn't. There was very little conversation, between the requester and the school district. So, the school district, my understanding is the school district just charged ahead and created a document, probably because they thought it was, well, I honestly don't know, maybe it was, easier to not let maybe some personnel, confidential personnel, information be accidentally released. But, if you're creating a document, the Public Records Act doesn't say you can charge for that creation just because it's saving you something.
My focus
They-
is not, I'm sorry, Sonia, go ahead.
No, I feel like I'm rambling a little bit, so go
My
ahead.
focus is not so much on the creation of the document, which is basically somebody typing the information into a computer and printing out one page. But somebody had to go and find the information that was necessary to create the document. And that process, I believe, would be something that would be able to be charged for under the act, right?
The searching.
And so, it seems to me that if we simply say, that we're focusing on, well, you just gave them a document that you created, and so you can't charge for anything else, we're missing the point, because somebody had to gather the information for purposes of creating the document. Now, maybe the time it took to sit down and create the document and typing it in and summarizing it, put it on the page, you can't charge for that. But gathering the information necessary to create the document, it seems to me clearly is something that could be charged for.
I think part of the problem is how they worded the bill. Am I wrong, Sonia? They basically billed for creating it?
The pleadings were fairly brief in this case, so I'm really just going on what the, district stated in its response is, this is what they did. I think maybe to clarify this opinion, we could put in a statement that says if, the, district, spent time searching for records, that would be, or, you know, searching, well, they obviously didn't redact anything, but if they spent time searching for records to compile the response, I don't know, I'm sort of,
Do we need more facts? I mean, it sounds to me like maybe they need to explain what they meant by compiling, because it may just be a poor choice of words.
It could be. I also feel like if, and we've had other cases like this before too, if you, as a public body, don't communicate with your requester and charge ahead before you, you explain or you, understand what you're able to recover for, you could get stuck doing extra work that you didn't need to.
Yeah, don't do the work until you get paid, because if they don't like the estimate and you've already done the work, then you're never gonna get reimbursed for the expense to the taxpayer.
Sonia, that's kind of where I'm hung up right there. Do we know when he paid the $132?
I believe it's in, I believe he, put that in his, complaint, but, I don't think I have that in the facts of the case. And I'm also on a Chromebook, so I can't look it up right now.
Here's my point, here's my point. Either they gave him the estimate before they gave him the document, and he paid it, or they gave him, he paid them when they handed him the document. To me.
My understanding is they gave him the estimate, he paid, and then they handed him the document.
Okay, if that's the case.
So he requested, yeah.
If that's the case, then to me, it seems, and this goes along with what Sam said, they put some effort in this. And so they did ask him, hey, is it okay that we give you this summary of the charges? It cost $132. If he paid them and took it, then he's saying, yes, that's okay with me, is he not?
I disagree there, because he has no way to know whether or not this document existed prior to the.
Okay, well, that answers my question then. He didn't know that was the document before he handed them the $132.
Right, I mean, he thought he was getting 2 pages, and there were, I mean, I don't know if, I honestly, I would be happy to take this off,
Mr. Chairman, may I make a suggestion, a motion that we table this matter pending further review and investigation of the underlying facts?
We have a motion to table pending investigation of further facts.
Could I ask a question before you?
Sure.
On paragraph 2.5, and this is in connection with this. There's in 2.5, there's 2 sentences in there, and I'm gonna read the second one first. It says a public body has the obligation under the statute to provide documents, has no obligation under the statute to provide documents that do not exist or to create documents to satisfy public records. I agree with that. The preceding sentence though says the Public Records Act does not allow a public body to recover the cost of compiling requested information. I don't think I agree with that sentence.
Well, it depends on what compiling means, because the statute the statute allows you to recover for 5 things: searching, reviewing, redacting, duplicating, and mailing. So if compiling includes searching, reviewing, and redacting, to me, it would include all 3 of those things, then maybe you can charge for
I think it does, but is the word that's in quotation marks, compiling requested information, is that in the act?
No.
I didn't think it
No.
was, so I think that sentence should be, it's confusing, I think that sentence should be deleted.
That's why Sonia's saying they can't charge for compiling, because that word's not in the act. But if it's just a poor choice of words, that's why I wonder if maybe the facts need to be developed a little more. Maybe that's just a poor choice of words. Maybe they did search and review before they compiled, and maybe that's what they're actually charging for. I'm not sure we really know.
But I guess, where I view this, and so, I guess it's a second sentence, Public Records Act does not allow public body to recover the cost of compiling requested information, and the way the sentence should end should be to create a new document. Okay, I don't think you should be able to unilaterally, recover the cost of compiling or searching for records to create a new document. If you're creating a new document that's not responding, that's not part of the searching for a responsive record, because you're creating
I'm not sure
one,
I
so you
agree.
don't have to.
I'm not sure I agree with that.
Because part of it necessarily has to be searching for the information that may be used to compile the new document.
Well, there's a motion on the table, on the table.
Let's go with that. We have a motion, to table. Do we have a second? We have a second. The motion is to table pending, further review and investigation of facts. Any discussion on that motion?
Yes, Mr. Chairman, Stephen, just Sonia, one thing, since it looks like this is going to be tabled, the other thing that we need more facts on is in section 2.6, where we talk about who the lowest level employee is competent to respond to the request, and I think you make an appropriate observation about the rate which is being charged. We obviously need information about who the lowest level employee is that could respond to the request.
Good point, thanks, Dan.
And how much that employee makes per.
Right.
Any other discussion on that? Good point, good point. Hearing no other discussion, all in favor indicate by saying aye.
Aye.
Those opposed, no. The ayes have it, and we're gonna table that one. That moves us to item L. Sonia?
Yes, sir. So this is my last case today, Public Records Case R-23-007, Ms. Lindsay versus a Clay County Circuit Clerk. My recommendation here is that the Circuit Clerk's Office be found to have violated the Public Records Act by redacting email addresses, telephone numbers, and mailing addresses from candidate qualifying forms. The circuit clerk had provided these documents but relied on an AG opinion that was issued to the Secretary of State's office to redact the email addresses, phone numbers, and mailing addresses. There's a couple reasons why the circuit clerk's office cannot rely on the Turner opinion. First, it was not issued to the Clay County Circuit Clerk, but to the Secretary of State's office. The, I guess, legal reasoning in the Turner opinion does not actually correctly apply the Public Records Act to candidate qualifying forms. The Turner opinion relied on a case law from New Hampshire, which specifically limits disclosure of records that would constitute an invasion of privacy. Our Mississippi Public Records Act does not have that same limitation or anywhere in our code. The other two cases that the Turner opinion relied on were actually dealing with specific records requests, dealing with personnel records, and this is not personnel records. In Mississippi, we in this opinion, I do caution the circuit clerk's office to when releasing sensitive personal information, that there is that tort of intentional tort of invasion of privacy. Under the three-part test in Mississippi, the email addresses, phone numbers, mailing addresses is not the type of information that would be considered highly offensive to a reasonable person to be revealed publicly. And also in Mississippi, public officials and candidates running for public office It's recognized that they voluntarily place themselves in the public eye, such that the release of information with regard to them is generally, it's a slightly, I don't know if it's higher or lower, but it's a slightly different bar than what would be considered, acceptable, to release about an ordinary citizen that would constitute invasion of privacy. So, in my recommendation, I'm recommending, no, that the circuit clerk I'm not recommending a fine, because I do believe that they relied on the, Turner opinion in good faith, but that there is no current exemption from the Public Records Act to redact email addresses, telephone numbers, and mailing addresses of, on candidate qualifying forms.
You did a good job on this opinion. It's something that a lot of people don't wanna give out telephone numbers and email addresses and so forth, especially, but you applied what I think is what the law is.
I agree, thank you, Samuel.
I was wondering about the distinction between Turner and how we're gonna get to there. I thought you did a great job.
Just for information purposes, have there been situations before where we have taken positions, directly opposite to what the Attorney General has taken?
Maybe this is the first one I remember, and I figured this would be inevitable because I didn't know about this particular opinion, I don't think, but I know that there are some out there where in the past where the AG's office sort of legislated a little bit. And I think this is probably one of those. Bobby, do you have any recollection or insight?
Not on this issue, another issue too.
Okay, so this is probably not the first time then.
The only other question I had was in looking at where it refers to, I don't remember the exact language, was statute, any federal or state statute, or court of, or opinion of the state of Mississippi, or other federal courts or something, I don't remember what exactly it was. So, my question was, did that provide some basis for determining that this information was privileged and confidential and therefore should not be, disclosed?
No, I think that's part of Sonia's point, is that for this particular information on these particular individuals, candidates running for public office, and their contact information, that, in other words, the only state or federal common law or statutory law provision that might apply would be invasion of privacy, and it doesn't apply to these people in this situation. She cited that Taylor Travis versus JSU case, which it's a great case for invasion of privacy. I won't bore y'all with the background on that one, but Judge Wingate here in Jackson Federal Court awarded, I think, $200,000 just for that one count of invasion of privacy. It was overturned by the Fifth Circuit, but in both cases there's a good discussion of that. And the best thing about the case is it makes the point that a public body can be caught between a rock and a hard place. Either you violate the Public Records Act or you get sued for invasion of privacy. So you've got to be really careful. I think that's Sonia's point here in citing that, is just because they're saying you got to turn over this contact information doesn't mean you can't get sued for turning over somebody else's contact information. So you've got to be really careful when it comes to anything that, for instance, that might be a personnel record, as it was in the Taylor Travis case.
And in this instance here, the request was for this specific information because it was a candidate. But I know if, like, when you provide emails that, to comply with a request, but they're not asking for addresses or email. I know personally, when I've compiled some that had cell phone numbers and email addresses and something that wasn't asked for, the document was asked for, but not that specific, I would redact it. Now, if they came back and filed a complaint, I don't know if that would hold up or not.
But you've got to exercise caution because you could get sued for invasion of privacy.
I exercise my own judgment because that information wasn't asked for.
I would say particularly if you're dealing with a public employee, I think you cannot, the public body cannot disclose their personal address, phone number. Those are personnel records normally, typically, those would be personnel records. And you'd be right back in this Taylor Travis situation when the judge is telling you gotta pay $200,000 because you gave up an employee's personal information. So
Sonia, Mr. Chairman, this is Steve, and I got one observation and then a question.
Go ahead, Steve.
My observation is, I'm a little dubious about the circuit clerk and the position they took in this because, to stand on a claimed principle about, I can't disclose addresses and telephone numbers, but at the same time, any one of us who choose to run for elective office can walk into the circuit clerk's office and for a fee, get a voter registration list of everyone in that county who is registered to vote, which often includes address and telephone numbers. So I'm a little dubious about somebody claiming that they're standing up for privacy rights when those, that information can be obtained for a fee by anyone who wants to get it. Second is, Tom, we talked about 6 to 9 meetings ago about, in relation to Turner, about whether the commission should ask the legislature to give us authority to issue preliminary or advisory opinions on the Public Records Act and the Open Meetings Act. And the last I heard of that was you were waiting to hear something from the Attorney General's office about whether they would be opposed or what their thoughts were on that. Has there been any update on that?
no, sir, I've talked with the AG's office and I've talked with the legislature and nothing has happened and I have not been told anything. I think your first point is an excellent point. I think that's why Sonia cited the Roberts case in paragraph 2.9, because as you said, you can get those voter rolls. And now there some information on the voter rolls is exempt, Social Security number, date of birth, maybe something else, but it doesn't preclude you from getting the other information. That's a good point.
Any other discussion?
We held the same matter was, a similar matter with, I think we dealt with Canada, very similar, recommendation and opinion last, June. I don't know, I can't remember what the case was, but it dealt with this, email addresses and telephone numbers.
Oh, I think that was an airport board. Somebody was asking for all contact information, and we said, I think we basically said they're not employees, so.
It was the Jackson, Municipal Airport Authority, and they were requesting all the travel records, and they had redacted, address information and other sensitive personal information of the Airport Authority Commission members, citing personnel records, and board members are not employees, so they couldn't rely on that exemption, and, we just said, you don't have a valid exemption. I do believe that the legislature should consider, putting in a sensitive personal information type, exemption. I think a lot of us, in terms of, identity theft, would be, would embrace something like that. But we don't have one right now, so there are no, aside from social security numbers, there's no overreaching, exemption, for private information under the Mississippi Public Records Act.
Do we have a motion regarding the staff's recommendation on this case?
I move we accept.
We have a motion to accept the staff's recommendation. Do we have a second?
Second.
We have a motion and a second. Any further discussion? All in favor indicate by saying aye.
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 All opposed, no. And the ayes have it. And that, motion carries. All right, we'll move on to our ethics advisory opinions, item M.
Can Sonya drop off?
No.
Okay, thank you, Sonya.
No. Oh, you're welcome. Do you still need me around?
No, it's up to you. I just wanted to thank you in case you scooted out.
Thank you, Sonia.
All right, Mr. Chairman, yes, sir, item M is opinion number 24-001E. This is one that the commission took up last month and tabled. The question is from a school board member who is an employee of a bank, not an officer. That would be a different ballgame under Supreme Court precedent, but an employee of a bank. The school district needs to borrow some money for a shortfall note. In the past, and I'm sorry, I've skipped the important part. School board member works at the local bank. In the past, the when the school district has solicited proposals for various types of borrowing money, banking, this has been the only bank that responded. And so, if it's the only bank that responds this time, they are concerned that they may have an issue and they want to know what to do about it. Under these circumstances, and this is consistent with a number of opinions we've issued in the past with banking issues, most of those involve, for instance, an alderman's spouse is a teller at the local bank. Can that bank be the depository? Similar situation, a contract with a bank, somebody connected to the board works there. This is consistent with those opinions, although it is factually slightly different. So the recommendation is that under these particular circumstances, under these facts, with this board member, the board member is not gonna have a prohibited financial interest in a promissory note between this district and this bank. The board member still would have to recuse from this matter, because you can't, vote on something that's gonna benefit your employer. And then under the prohibitions of section 3A, there is an exception that applies for banks being depository or loaning money to a governmental entity. And you see the opinions listed on lines 15 through 16, it's page 5. Those are a number of opinions that are consistent with the finding in this recommendation. So that's my recommendation in this opinion, is for the commission to issue an opinion that will permit this board to borrow money from this bank under these circumstances if they are the lowest bidder.
All right, we have the recommendation. Any discussion? Bobby?
Just a typo in the very first part with the question presented. Employees.
Oh, yeah, I wonder why the spell check didn't catch that. Thank you, Bobby. Thank you for paying attention.
Well, just jumped out at me.
Mr. Chairman, this is Stephen.
Yes, Stephen.
I have a philosophical question about this case because we tabled it before, and I make this observation, or I ask this question in conjunction with the opinion we rendered, I believe, in December involving the former supervisor who was the clerk at the hardware store. The only one in the county, and the commission told the county they could not purchase anything at that hardware store because of the conflict, as long as during the period of time under section 109, 1 year after the term of office for that former supervisor ended. And I remember the statement, we used it a number of times in other opinions, which is, and I'm paraphrasing, but I think I'm pretty close, an employee has an interest in an indirect or direct interest in all the income earned by the employer. And so I have zero problem in this proposal with your statutory evaluation. My comment is limited solely to section 109. So here we are, and I get everything you say is probably absolutely true as far as this woman's income, her job is not going to be affected in any way if this government body obtains a loan from this lender. But, if we adopt this opinion, then I feel like we need to stop using in subsequent opinions the statement, the pronouncement that we've made that an employee basically has automatically an indirect interest in the employer's income. Because if we're telling the supervisor, the former supervisor, that your county cannot buy a box of nails from the hardware store at which you work, but we're going to tell the loan officer, who happens to be a member of this public body, that your bank can potentially earn tens or hundreds of thousands of dollars in interest on a loan that your government body will do, and you have no indirect interest in that, then we need to strike forever that particular statement from our lexicon, and it needs to never appear again. And that's just my opinion, but I would appreciate your thoughts on that.
Stephen, those are excellent points. And I think you have summarized what to me is one of the most difficult parts of our job. I told my wife the other night, I've been doing this for 20 years, and instead of getting easier, it seems to be getting harder. And this is the thing that gets harder. What is an indirect interest? The thing that bothers me about this, the same thing bothers me that bothers you. And the thing that bothers me most about the opinion in December to the guy at the local store is one of the things that's always bothered me about our application to Section 109 is that it unintentionally discriminates against small businesses. This bank, this individual bank, forget, holding companies or who owns the store that the ex-supervisor worked for or anything like that. It's bigger than that one little store. That helps dilute it some, but we're not talking about Walmart versus Ace Hardware here. So it's not that dramatic a comparison. We've also, frankly, made some sort of implied exceptions for banks over the years, because in so many small towns, they run into this real problem where nobody else will respond. This is not the only bank in this town, and it's not the only bank in this region, but it's the only one that they've been able to get a response from when they've tried to borrow money. You may have the same thing with the hardware store, but we've just told people, you got to drive to the next town, drive to the next county. These people can't necessarily drive anywhere if nobody will sell them, what they need, in this case, debt. So it's a really difficult problem, and I am frustrated over and over again that I can't give y'all a nice, neat solution. But you're asking you're asking exactly the right question, Stephen. You've hit on exactly the right problem. Unfortunately, I'm frustrated that I'm not able to provide a really good answer. I think the opinions the commission's issued in the last couple of months, we've got one today, where under certain circumstances, the commission has taken a position that not only does your pay have to be segregated from the public funds, but you gotta work for a separate company. That's a clear, bright line. Actually, the same lawyer that requested this one called me about something totally unrelated yesterday, and we talked about that in this unrelated issue, but it was a smaller business than the ones we've talked about before, and a smaller contract. She said, I don't think any of them are gonna be willing to set up a separate business for 7 months or whatever. It was a former board member who'd gone to work with the business. So there are a lot of ways that this particular provision creates difficult questions or problems for us, and there's not one solution, unfortunately, for all of those problems. I have said recently that probably the best thing I can say about Section 109 is it's probably better than nothing. And what you hit on is an example. I mean, it may be better than having no restrictions on public officials, but it sure is hard to apply fairly in situations like this.
Well, in terms of being fair, if the commission adopts this opinion, then I intend, and I may not get a second, I I intend to move immediately to rescind that prior opinion with the former supervisor in the hardware store. And I get, it's one thing if the county had bought a John Deere tractor for $150,000. I understand that and the distinction between, that and a box of nails. But I personally cannot reconcile the two. And it's either we gotta do one or we gotta go the other. And I don't mean to make a fork in the road, and I'm not trying to be dramatic in any way, but this is to me, at least mentally, a fork in the road. Which way are we going to go? And maybe I don't mean to make that big an issue. I hate to do this with only 5 people present on the phone, or at the meeting. But I'd be interested to hear what everybody else has to say.
Well, I wonder how far back we would need to go, with previous opinions that are based upon this.
And I wonder, I don't have any opposition to what you're talking about, Stephen. I only have questions like, what is the next step? I mean, we've got an opinion on here today, another opinion on here today that I don't have any problem with under those particular facts, because you're talking about a small amount of business, a small amount of money. But what do you do when the guy is gonna make $1 million? You know, how do you distinguish between the two? Because Section 109 makes no distinction in the amount. At least in some of the statutes, we have amounts for levels of interest. But that's one of my problems with Section 109 is it doesn't make any distinction between a penny and $1 million. So I don't know how we tell the guy at the hardware. I want to tell the guy at the hardware store it's okay, but I don't know how we distinguish between him and the guy that owns the hardware store.
How do you distinguish between him and the banker?
Now you're asking Stephen's question in a harder way.
Boy, it's a little more direct.
You're putting another nail in me.
Sorry about
Stephen
that.
was at least just shoved against the wall.
Sorry about that.
No, these are the same, y'all, these are the same questions I asked myself for 20 years. And they're just not a good distinction. That's all where this comes down to. We all wanna be fair, we all wanna be consistent, but we also don't wanna let unscrupulous public officials have free reign.
Because I guess, literally speaking, to maybe to Stephen's point is, it's an indirect interest.
Yeah.
Whether it's a penny or whether it's $1 million.
Exactly.
You know, and it gets back to this question of what is, at some point, it's so de minimis that you don't count it anymore.
Yes.
You know, but
De minimis is a valid concept because the Supreme Court said it was. Of course, they didn't define it. We have tried to define it by using some of the by borrowing some of the statutory definitions, and that's helpful sometimes, but it's only been helpful where we're talking about a small amount of stock ownership. We've said that's a de minimis interest because it's under this threshold that the legislature created, and we think that's a good yardstick. But, you know, here, this doesn't fit because this person's a full-time employee. It's not like they're making, you know, not like they have 0.0045% of the stock and they're making $230 a year. That's what we've said was de minimis. She does not have a de minimis interest in the bank. And we're not technically saying here she has a de minimis interest in the contract. Remoteness is another concept that the court has come up with. And that's kind of what we use for the Walmart scenario. If the guy was working at Walmart or Lowe's instead of the local privately owned hardware store, we'd say his interest is so remote that it's not prohibited. That's where we get into this unfairness between the big business and the small business. So we've got these tools out here floating around, but they're limited in their application, and de minimis is a good example of that. It's useful in some situations, but not in this one. Ironically, it would be easier to write this opinion if this board member was owned stock in the bank and didn't work there, and it was a relatively small percentage of stock. That would be easier. Sorry, I'm just starting to gripe now. I like my job, don't get me wrong, but it's just, Section 109 is I wish somebody would go to the Supreme Court and argue that it's unconstitutionally vague. I would like to see how that comes out. My understanding from law school, which was a long time ago, is that if a reasonable person can't understand what conduct is prohibited, then it's unconstitutionally vague. And we've all spent a lot of time trying to figure out what's prohibited by section 109, and I'm not sure any of us really knows. I had a conversation with the chairman earlier this week about the same deal in another context, and you know, he's been doing this 40 years, and he's got the same frustration that I have. And Sam and Stephen, I'm sorry, that's just a long way of not answering your questions. I apologize for that too. Nick, did I speak while you were trying to say something?
Well, yeah, no, that's fine. All I was gonna say, for me, I get the 109 argument indirect, but for me, the whole thing just turns on, well, what is the intent of the person? Are they using their position to gain a pecuniary interest? To me, that's what everything turns on. And I think that's what the legislative intent of the statute is, and I think that, I mean, it's the same song, second, third, fourth, 15th verse, whatever, what is that indirect interest? But to me, I think it depends on looking at the situation, and I just don't think you can do everything with one brush. So I get the big and small argument, but what are they using their position for pecuniary interest? And that's what I think it turns on for me.
And that is prohibited under subsection 1, but under subsection 2 and section 109, they don't require intent. They don't even require, one thing I teach in seminars, they don't even require that the public official do anything. It's a prohibition against an interest in something that the board does. So if you're an alderman and the city clerk goes and buys something from your store and doesn't tell you, and she puts it on the claims docket and you're not at the meeting, and you never look at the claims docket and the board approves payment of that claim, you're in violation of section 109. You didn't know it, you didn't do it, but you're in violation of the law. It's a very strict type of strict liability.
Well, maybe the short answer here, Mr. Chairman, at this point, I'm not saying I'm can't be persuaded, but at this point, I'm dead set against this. And since we barely have a quorum, and we face the possibility of not being able to make any decisions today, I'd like to make a motion, and I hate to do this, and I hate kicking the can down the road, but maybe what we need to do is table this until next month, and hopefully, have all 8 members of the commission on board so that we can address this issue and finally give these people an answer that they deserve.
Stephen, I don't mean to speak against that at all, but I feel compelled to share some more information. When I talked to the board attorney yesterday, we did talk about this in addition to the other things she called about. And she said that they are watching interest rates closely because they budgeted for whatever the interest rate was at the time. And she didn't say that delays could, scuttle them. But she said that if the interest rates go up, it could be a budgetary problem for them. So that I'm just conveying to you what she told me. I feel like I owe it to her to tell the commission that if this is gonna get tabled for whatever reason, just to make y'all aware. I'm not trying to influence what y'all do. I just wanna make you aware of that, of those facts.
So there's no prohibition in going out and getting quotes from other banks?
No, there's not. And she did explain to me that one of the problems is this is a very small community. I don't think they're prohibited from advertising in other newspapers or going out to the banks and asking. But there's only 2 banks in town, and the other bank has never responded to any of their publications. And so I mentioned that yesterday. Y'all may need to go, next county over and go knock on some doors of some banks and get some more. See if somebody will loan you the money. And I'd be glad to tell her that from y'all, if that's the consensus, if that's something they need to do.
All right, we've got, Stephen, do we have a motion on the table?
Yes, Mr. Chairman, that's a motion to table until our April meeting.
We have a motion on the table, to move this to our April meeting. Do we have a second? We have a motion and a second, on that, and is there any discussion? The one thing I would like to say about that motion, to table is Steve and I agree with you, we hate kicking things down the road, but this is a decision that it's just far reaching. We deal with this all the time. Tom and them do a great job trying to get fairness and figure these things out, but it's coming to a thing where a decision's gonna have to be made, and I appreciate the position this might put them in, Tom, but hey, if we said no today, they still got that same problem. So, or if we're not able to make a decision today because of the number of votes that are cast and how they're cast, they've still got the same problem. So, I guess I'm just running around, Stephen, saying I agree with the motion. Anybody else have any
Takes
discussion?
5 votes to pass it, so.
Right.
We have 5.
That's what I mean.
Yeah.
We'll have the same problem.
Right, right.
So guess I'm just speaking in favor of the motion table. Any other discussion? All in favor indicate by saying aye.
Aye.
All opposed, no. The ayes have it, it'll be unanimously decided, accepted. All right, the next one.
Mr. Chairman, item N is opinion number 24003. This is another one of the more difficult, questions that we have to deal with. This is a former public servant, and we're looking at subsection 3E. This person's a former state employee who had a high-ranking position at the state agency, deputy executive director, and they were the chief professional person at the agency. They've now retired, gone out into the private sector, and of course, the law doesn't prohibit this person from working for a firm that contracts with their former agency. It just prohibits the firm from paying this person to work on any matter that they were personally or directly involved in while they were a state employee. So, as always, the first issue or first question is, what is the matter in question? What is the case, decision, proceeding, or application we're talking about here? The requester has laid that out for us in these contracts that he's described. The firm he works for now has contracts with the agency. There's a master contract, and there's, what were the other types? I forget how we described them now. I forget the name we used, but anyways, I think 3 contracts of 2 types. And so the question, that part was pretty easy. The question is, was this person personally or directly involved in those contracts, in the procurement of those contracts, or the supervision of those contracts, or paying those contracts, or whatever? He argues that he was not, and we get this argument from time to time from people who are highly placed in an agency. And as the way I've explained it to people is, the higher up you are on the org chart, the more likely it is that you were personally and directly involved in everything that went on under you on the org chart. And I think that's a case of this. He basically says, I didn't really do anything with these contracts. We had a committee that did that. Well, he's involved with who's on the committee, he accepts their recommendations, and he actually signed the contract. So I think that's enough to constitute personal and direct involvement. And apparently I'm not the only one who thinks that. And so my recommendation is to tell this individual that, no, you can't work for your private sector employer on those particular contracts. Of course, anything that started after you retired, you can work on that because you would not have been personally directly involved. So typically these contracts expire at some point, and we've said time and time again, if it expired, if it's renewed after you retired, then you can work on it in the private sector because you didn't have anything to do with that particular contract. So that's my recommendation in response to this request.
Well, just because I signed it.
We had many requests from former employees from this particular agency.
Yes. Yes.
Because this is exactly what they all do.
Yep.
Exactly.
And some of the answer, and I think what's confusing to a lot of people, because people talk. And I think what's happened over the last several years is, our opinions are, some are yes and some are no. They're all fact dependent. And somebody would get a yes answer and they go shopping around with their coworkers and say, hey, I can go do what I want. The Ethics Commission said I'm free to do what I want. Then a year later, you get a request from somebody else who's retiring, and it's similar, and they think the answer is gonna be yes. The answer is no, because they were in a different job and they had a different role and they did different things. And so it's interesting to see, without hearing from anybody at the agency about it, you can read the breadcrumbs and see kind of what's going on, because as you said, it's what everybody does from over there.
All right, we have a recommendation, do we have a motion?
Motion to approve staff recommendation.
A motion to approve, a second?
Second.
And we have a second, is there any discussion on this one? Hearing none, all in favor indicate by saying aye.
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 All opposed, no. The ayes have it, and it's unanimously accepted. Item O.
Mr. Chairman, item O is opinion 24004. This opinion is requested by a mayor who's currently in office, but the reason the opinion says a former mayor is because he says he intends to resign as mayor. He's gonna retire, but he's been offered another job with an insurance business. The business is affiliated with the city's insurance agency. When this was first presented to me informally, the question was basically, can the mayor resign? He's retiring from his day job is what's going on, and that plays into his resignation as mayor. It's not that he's looking for this other job, it's all about his retirement from his day job. But the question was, can the mayor resign and then immediately go to work for the city's insurance agency? And I sent the attorney some prior opinions and said, the answer is likely to be no based on this prior opinion, because he's probably gonna have an interest in this contract. But that can be different with insurance agents. If he's only paid a commission on his own sales, then he may not, and no salary, then he probably wouldn't have an interest in this contract. So we discussed all those options, and I was told, well, that's probably not gonna work, we're just probably not gonna request an opinion. But then when I did get an opinion request, it's directly from the mayor, and the facts were a little different. He's asking, can I go to work for a separate company that is affiliated with the insurance agency, but separate? And so this draft opinion is based entirely on the ones that we've issued recently that were like that. Remember there was one to a former supervisor who just left office, and we said, not enough just to segregate the funds that go into your paycheck, you've also got to work for a separate company. This opinion says essentially the same thing. No violation will arise if the former mayor is employed by an affiliated but separate insurance agency which has no contract with the city, and if he is paid with funds segregated from funds paid by the city. And we cite one of those recent opinions for that proposition. So this is consistent with the ones we issued recently, and that's my recommendation in response to this request.
I had a question on this one. Why would they ask for this opinion?
Why, in the sense that,
If it's an affiliated agency, it's not the agency that the city has a contract with, that's a clear cut thing. So why is it not, and maybe I'm just speculating, why is it not just as obvious, hey, well, I'm working for an agency that's not.
So you're saying
the city.
The answer is so obvious, why would they ask the question?
Exactly.
I think probably the number one reason is probably because of my prior discussions with the city attorney. And that was before these recent opinions. And so, the mayor may have some knowledge of the commission's position on these recent opinions.
Okay.
So maybe he went back to them and said, can I work for this other agency? I don't know how this agency is structured. That never came up in the discussion, so I don't have any background knowledge there. And I just have to speculate, but I think some of it must be related to my prior discussions with the city attorney, where I said the answer is probably gonna be no.
And if it was structured so that it would create a violation, this doesn't protect him, does it?
Correct.
Okay.
If he goes to work for the city's insurance agency and he's paid by them, and they're not segregating funds from the city, then this opinion's no good.
It doesn't help him.
Right, because that's not what he asked.
And Mr. Chairman, this is Stephen, that last sentence in the actual request, which is not, which of course is confidential and not on the screen, that's kind of what seals the deal for me in this, because the statement is, no compensation or benefits directly or indirectly are received from the contracting insurance agency. And to me, that would include any investment capital, operating funds. This has got to be completely separate, and nothing, the two shall never meet, I guess, so to speak, when it comes to finances.
Yeah, that's a good point.
Tom, I had one other question. This is a bit of an aside, but it just kind of got my attention. The request suggests that the policy is presented to, the board for approval, and the mayor, almost as if the mayor doesn't have any involvement in it. Am I reading too much into that, or?
No, I don't think so. I think that's
The former mayor is not suggesting that she doesn't have anything to do with the approval of the insurance for the city.
No, not really. I think you're correct in reading it that way, but I think it's a good question, and it comes up a lot with mayors. And of course, we have lots of different forms of municipal government. In Mississippi, we have 4 or 5 different code charter, and then special charter, and mayors do different things in different, or have different authority in different cities and towns. But the one thing that the commission has consistently said about that is that mayors are part of the governing authority, no matter what form of government, and we're gonna treat them just like an alderman or selectman or councilman, and say they are subject to section 109. And
Okay.
I think we've never been challenged on that in court. Supreme Court's never spoken to it, but I think that's certainly at least a facially valid interpretation. But every once in a while, a mayor will say, well, you know, I just presided. I only vote in the case of a tie, so, you know, can I do what I want? And our answer is generally, no, you're treated like a board member.
Okay, thank you.
Do you have a motion regarding this recommendation?
Mr. Chairman, I'll make a motion, we adopt.
We have a motion to adopt, and we have a second. Any other discussion? All in favor indicate by saying aye.
Aye.
All opposed, no. The ayes have it, that'll pass unanimously. Item P.
Mr. Chairman, item P is opinion 24005. I think this is a creative request. The question is, well, let me sort of put it in context. The question is, if the sheriff can delegate running the jail to a jail administrator, can the jail administrator hire the sheriff's child to work at the jail? And my draft answer is no. We've issued a couple of opinions similar to this before. I cited some of the same statutes we've cited before with regard to sheriffs and how much authority they have. It's just interesting to me that when a county official gets into it with other county officials, they try to claim they have all the authority in the world. But then when they want to hire their kid, they claim they don't have any authority. That's what's going on here, and I just couldn't, I'm sorry, but I couldn't help but make that observation. But no, sheriffs have complete authority over the jail, and I don't think we should say, and we haven't said, that just because you delegate that authority means that you get to do whatever you want. So, also I had to point out here that the DAG opinion they cited for the sheriff's ability to delegate authority to a jail administrator also says, quote, "It is our opinion that jail employees are considered to be employees of the sheriff and not of the board of supervisors." So they're still his employees. Sheriff shouldn't have his daughter working for him. Also cite the nepotism law and advise him to contact the Attorney General's office for advice on that statute. That is my draft recommendation.
Do we have a motion regarding this recommendation?
I move we accept.
Do we have a second?
Second.
We have a second. Any discussion? All in favor indicate by saying aye.
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 All opposed, no. The ayes have it, and it is unanimously accepted. Item Q.
Mr. Chairman, item Q is opinion number 24006. Question is whether a county can purchase gravel from a business owned by the financially independent father of a supervisor. So, as with any question involving a transaction with somebody connected to a member of a public board, we have to first ask, are these two people, the board member and the other person, financially independent? If they are, then the board member does not have a prohibited interest in the transaction. Second, where the other person is a relative, we have to remind folks, you have to recuse yourself from anything that would benefit your relative. So that is the answer here. It's, we've issued many opinions to this effect. As long as the board member and the vendor are financially independent and the board member recuses from anything that would benefit the relative, then the county can do business with the board member's relative business.
Do we have a motion regarding the staff's recommendation?
Move to accept staff recommendation.
And a second?
Second.
And we have a second. Is there any discussion on this one? All in favor indicate by saying aye.
Aye.
All opposed, no.
Aye.
The ayes have it, it's unanimously accepted. Item R.
Mr. Chairman, item R is opinion number 24007. I alluded to this opinion earlier as another section 109 issue. This is, and I think the way this happened is not legally relevant, but it's important to understanding at least my sort of initial approach to this. You have a legislator who owns a business that, probably not his only business, I think it's a pretty small business, but it's a business that provides short-term housing to anybody that comes along. And he was approached by a manager with a construction company and said, I need to rent some spaces for some of my workers. And I think what happened was, just in the course of conversation, the legislator asked, oh, what are y'all doing around here? And so we're working on that highway project. And this rings a bell with the legislator. He knows this project. He voted for this project. He's in favor of this project, and he recognized, to his credit, that this might be an ethics issue if he's doing business with somebody who's working on a highway project. Now, this is not the general contractor on the project. It's a subcontractor. Okay, so he's providing a service to a company that is a subcontractor on a state project. The law does not go so far as to say this legislator can never do business with anybody who's ever been a subcontractor on a state project. I think if this transaction was not directly involved in this project, let's say they were building a hotel, right? They got the highway project going on somewhere, but they're building a hotel in this guy's town. And they want to rent accommodations for the workers to work on the hotel. I think that would be a very different question, because it would be hard to say that transaction was authorized by the legislature, because they're not working on a state project. You can still make the argument that, well, you follow the money, he's got an interest in this, it's somehow authorized by the legislature because this company does get state money for doing other stuff. But that's where you get into this edge of the target stuff that the Supreme Court's talking about. You know, the law, just as I said, doesn't go so far as to prohibit a legislator from ever doing business with anybody that has been a subcontractor on a state project. This is somewhere in between. And, you know, we were talking earlier about, is somebody gaining an advantage from a situation like this? Are they somehow using their position? No, this is purely incidental. If this guy hadn't asked, hey, what are y'all doing around here? He would never have known. Could it have still been a Section 109 violation? Yes. But we're talking about presumably a kind of a drop in the bucket transaction, short-term thing. Not saying it's not important to this guy's business. I don't know what the scope of it is. But it's not like this guy is selling $1 million worth of material to this subcontractor to use on the state construction project. That would be a very different factual scenario. But I don't know how you distinguish between this and that. And this is, I don't mean to dredge up our discussion earlier, but this is why I mentioned it earlier. There are good arguments for telling this person, yes, under these circumstances, this is not prohibited. But I don't know how you make a distinction between this small transaction and an identical transaction with a much larger price tag.
I think, frankly, that this particular transaction is not necessarily that small.
Okay.
Because you're talking about, as I appreciate what he's talking about leasing 10 spots for an extended period of time. This project will extend for more than a year in all likelihood. So I think that from a financial standpoint, it probably is a little bit, it's not probably $1 million, but it's not insignificant.
I didn't think about that. If this subcontractor is working on the entire project as opposed to just one portion of it, and I don't know what the scope of their work is, then it could be a long-term deal. Yeah.
They'll be down
you see my point?
Yeah.
And that makes me feel better about the answer, about telling the guy no. But if this was a one night for one person, then it makes, it's just me changing the facts to give an example of how difficult it can be to be fair and consistent at the same time. At least if you tell everybody no, you're being consistent. I think that has been a philosophy used in times past with these questions, and there is some fairness in being consistent. But it just, I think, is another illustration how difficult it is to do the right thing every time.
Yeah, and Tommy, you know I've got a little heartburn on this one. I find it really difficult, and that you're putting some of these elected officials in a difficult situation, especially the legislature that vote on so much stuff. It's almost like they have to vet every single thing that they do in their private lives. And like Sam said, I don't think this is an insignificant amount of money. I think it's a rather large sum. But just to me, is it not just too far removed from the contract with the state? That's my question to you.
Mm-hmm.
You got a subcontractor who, I don't know how they get paid. I don't know if I assume they're getting paid with state money, but we don't know that. Or they get paid with something else. I assume the state through the bidding and all that stuff. But he's dealing with somebody that doesn't even have a contract with the state per se. They have a contract with a private company.
Mm-hmm. Yeah, you've hit on the question, Nick, and like Stephen's question earlier, there are not good answers, not really solid answers for that. I think, again, under these circumstances, you can change the facts just a little bit and get very different answers. The edge to the target thing that I mentioned earlier, that phrase has been used in more than one Supreme Court decision on Section 109. But like de minimis, the court they've acknowledged that there's an edge to the target, but they haven't drawn the edge. They haven't told us where the edge is. They've said things like, there's an edge to the target and this is outside of it. Well, that was a Medicaid case, and so that changed the way we approached, can a legislator be employed by a Medicaid provider? The answer, since that case, is yes. There are some other answers there, like, well, what can they vote on? Well, that was not exactly nailed down in that case. So this is kind of similar to that, and I agree with you. I don't think the law imposes a duty on every legislator to do an audit of every one of their customers to find out if they have state money, where it came from, what they're using it for. I think it's a pretty safe bet, and I would defer to y'all, particularly you and Sam on this, but I think it's a pretty safe bet that this subcontractor is getting paid by the contractor with state money. And they may not be paying this guy's bill before they get the state money, but they're at least gonna be reimbursed for it with state money at some point, so.
What makes that part a little bit more complicated is you don't know what type of project it is. It could very well be a project where the federal government's paying 90% of it.
Yes, but the state agency has been authorized by the legislature to spend that federal money, arguably.
Yeah, okay.
And so I think the short answer, those are valid points. The short answer I have given to legislators in the past, because I've always tried to give safe advice, is you need to assume that you cannot do business with a state agency, because I don't think a state agency can spend any money unless the legislature has authorized them to do it one way or another. And you can get into escalation clauses and what's DFA's authority and one fiscal year to another. There's a lot of details buried in that, but I try to give people, the safest answer, and I think the safest answer is this has been authorized by the legislature somehow or another.
Hey, Tom, this is Stephen. I hate to play kind of what if or gotcha. If you don't want to answer, I understand, but what if, take the same set of circumstances and the subcontractor goes out and hires a labor services company? Hey, I need 100 workers on this project, and the labor services company then contacts this former legislator and says, hey, we want to rent your spots here. So we've added another layer to this. And I get that everything is fact intensive, but I guess I'm trying to see where the edge of the target might be.
Yep, that's a great question, Stephen, and it perfectly illustrates how we don't know where the edge of the target is. There have been some opinions where we've said this is beyond the target. We've never drawn a line with contractors, subcontractors, vendors, suppliers, like how far removed do you have to be from the general contractor before this restriction goes away? I don't know. That's similar to what Nick was just asking. But you're creating a great hypothetical. What if this was a contractor to a subcontractor? Would that be far enough that it's beyond the target? We just don't know. And
Tom, one more question. I'm sorry, go ahead.
no, I was pretty much finished. Please go ahead.
I'm just gonna ask one more question, and I don't know if it's spoke to this or not. How are they paying the legislature? Is the subcontractor paying it, or do they give the money to their employees and the employees pay the rent or something? I don't, did it speak to that?
I don't know, and my sense from talking with this legislator is I don't think they got that far. I think once he realized they were a subcontractor on a state project, he called a timeout. So I'm guessing he doesn't know either. Now, we could ask him to go find out. We could, if y'all wanted to, anytime y'all wanna table it and ask me to go get more information, we can always do that. He did say that time is of the essence because they need to get, the subcontractor needs to get working, so he may not, if he's gotta wait another month, he may say, forget it, I don't know. He's obviously being cautious. When he talked to me about it, he said, look, I don't wanna do anything, cross any lines. I told him there's not really a good answer to that, so, it's not like I could send him a prior opinion on point. We don't really have anything exactly like this, and I advised him to request an opinion, so I'm pretty sure unless he gets a favorable opinion, he's not gonna proceed with it. But y'all are always welcome to table it.
Another layer to that, what if this contract is with the individual renter, the person? Does that change the situation?
That's another good question, and if I were the landlord, I might wanna do it that way. I might want the guy staying there to be the one responsible, so I can throw him out if he acts up or whatever. What if? I mean, what if I'm on state business, and I go to Gulfport for the, municipal conference, and I stay at a hotel, and I use my credit card, I get reimbursed, and then I find out later on that a legislator owns 60% of that hotel. Is that a violation? I don't know. I don't know that anybody would ever figure out that it happened that way because I'm just an individual using my personal credit card, but I'm being reimbursed by funds appropriated by the legislature. So these are all excellent questions, and welcome to my world. These are the kind of this is the way I spend my spare time, is worrying about this stuff. But it just I have had to learn to live with the discomfort of not having solid answers on these questions. So again, I apologize for that, but it's just the hand we're dealt. Nick, are you still glad you got appointed to the Ethics Commission?
Absolutely, yeah, this is great, great exercise, absolutely.
It's not worth $40 though, is it?
It's 40 a day, not an hour.
That's right.
Is that, any other discussion, questions on this one? Well, do we have a motion regarding the staff's recommendation? I'll say part of me, with this whole edge thing, I do wonder, well, it might matter how far away, if there's how many people between them.
I'm gonna move that we accept the staff's recommendation.
We have a motion to accept the staff's recommendation. Is there a second?
I'll second, because there's enough information in the request to settle the issue in my mind.
We have a motion and a second. Any other discussion? All in favor indicate by saying aye.
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 All opposed, no. The ayes have it and be unanimously accepted. Item S.
Mr. Chairman, item S is opinion number 24008. This one just came in. I apologize for the lateness of this one, but it just came in, and I was informed that this one was time sensitive as well. And you'll see why if you've had a chance to read it. So the school district all school districts have federal money right now, and they're all trying to use it before they lose it. And this school, you heard of that? This school district hired a contractor with federal money to do a project. Construction company starts the project. It's still ongoing. While it's ongoing, they get a new school board member who I think got elected. I think is elected school board member. Took office in January, I believe. Sometime after the new board member takes office, they find out that the new board member is employed by this same contractor. And they realize they've got an ethics problem. We said a number of times in a number of different scenarios, and I've cited, I think, a couple of those opinions in here. Yeah, line 9, 1, 2, 3, 4, 5, 6 opinions. I went back several years and found that many. Where in different contexts we've said if the contract was authorized before the person went on the board, then it doesn't violate Section 109. Because Section 109 prohibition only kicks in when the person takes office. So we've had that, for instance, with 16th section leases. If it's authorized before they go on the board, not necessarily a problem. We've had some other real property issues. We've had one of my favorites was where it was a city. They only found one guy to do the work at the ball field. He got delayed by COVID. In the meantime, they had a vacancy. They had one person qualified to run for alderman. She gets on the board. Guess who her husband is? The contractor. You know, it's amazing how often this kind of weird stuff can happen. Well, that happened here, and they want to know if they can finish the job. If they don't finish it pretty quickly, they lose the money and they got a mess. And how do you find somebody to come in and be a substitute contractor once this guy's already been paid some and doing the work? I mean, it's just it's an unfortunate mess. But fortunately for them, we have answered this same basic question a number of times before and said under Section 109 at least there's no violation. You still got subsection 1 to deal with. Obviously, this new board member cannot vote on anything that's going to result in monetary benefit to their employer. And then under subsection 3A, and this is the only part that's slightly different from some of the other opinions. Under subsection 3A, you can't have a material financial interest in a business that's a contractor to your own governmental entity. As a full-time employee, this person undoubtedly has a material financial interest in the company. The company's already a contractor. This kicks in as soon as the board member takes office, so we have to look at exceptions for that particular prohibition. And the catch-all, so to speak, is in subsection 4D. It says if the vendor or contractor is providing services or goods that are reasonably available from 2 or fewer commercial sources, then the exception applies and you can do business with them. In my estimation, under these particular strange facts, and limited to these particular strange facts, this contractor under these circumstances is one of 2 or fewer reasonably available sources to finish this work. So I think under all 3 of those prohibitions, these facts clear muster. My recommendation is to allow, to tell them yes and say yes, this contractor can finish this job under these limited circumstances.
And recusal on anything having to do with this, whether it's to agree to the claim or whatever, clears him.
Yes, absolutely. The board member has to recuse. How did I phrase it? The trustee must recuse from any action by the board which would benefit the company, including but not limited to approving change orders or claims for payment to the company. If y'all want to add anything else to that laundry list, I'd be happy to. But those are the first couple of things that jumped out at me.
Any discussion or questions?
This is Stephen. In the context of the paragraph regarding section 109, hasn't the commission in prior opinions said that payment under a contract is a ratification of that contract?
We have said that, but we've also said where the contract was authorized before the new member went on the board, then payments made pursuant to that authorization are not a reauthorization. So in other words, and maybe I should go back and add that, like a change order might be absolutely prohibited. In other words, you can't enter into a new contract after this person goes on the board. All the payments you make have got to be done under the prior authorized existing contract. Does that make sense, Stephen?
Yes.
Do y'all think any amendment needs to be made?
I'll jump the gun. I'll make a motion to adopt the staff recommendation subject to the addition of a sentence in the first paragraph under the analysis, which clarifies that although normally a payment under an existing contract by a public body is a ratification of that contract, that in this instance, since this is the fulfillment of terms which are already in existence and I guess to be done, Tom, you're wording appropriately that doesn't apply in this particular circumstance.
You think if I could find a construction lawyer who's willing to give me some pro bono help, maybe he might have some magic words I could use?
I don't know.
All right, we have a motion on the table. Do we have a second?
Second.
We have a motion to second. Any other discussion? All in favor indicate by saying aye.
Aye.
All opposed, no. The ayes have it, it's unanimously accepted. All right, that gets us down to item T, which is just setting the time for our next meeting. Normally our next meeting will be on April the 5th. That's the first Friday in April. Anybody have a problem or an issue with that they know of already? Then we will leave it set for April the 5th. At this time, I make a motion to determine whether the commission should declare an executive session. It doesn't require a second, so all in favor indicate by saying aye.
Aye.
All opposed, no. The ayes have it, and that is unanimously agreed to. In lieu of entering the closed session and announcing the reason to enter executive session, the commission will have this discussion in an open session. Do we have a motion regarding our executive session?
Yes, Mr. Chairman, I make a motion that we enter executive session for two reasons. One, the ethics laws requires all commission proceedings about investigations to be kept confidential, and we need to enter executive session to discuss investigative proceedings regarding alleged violations of the ethics laws. And two, we also need to enter executive session to discuss strategy about prospective litigation because an open meeting would have a detrimental effect on our litigating position.
We have a motion. This one does require a second. Do we have a second?
Second.
We have a motion and a second. Any discussion on that? All in favor indicate by saying aye.
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 And all opposed, no. The ayes have it, and that's unanimously accepted. So we'll enter executive session at this time. Let's move everybody on Zoom call. It's a spectator, not a commission member, and move everybody on Zoom.
They're in executive session.
Oh, yeah.
Hey, who would I talk to about, looking at minutes from past meetings?
Tom.
Tom, okay.
we have re-entered, our open session, and we have conducted and concluded our business. Do we have a motion?
Move adjourn, Mr. Chairman.
Do we have a second?
Second.
Any discussion on that motion? Hearing none, all in favor indicate by saying aye.
Aye.
All opposed, no. And by unanimous vote, we are adjourned. Thank y'all very much, guys. Appreciate everybody.
Thank you very much,
Thank you.
everybody.
Hey, Jose Sema, I'm the assistant director here.
Hi, St. Miller.
Nice to meet you.
Very nice to see you.
Mr. Good, we met earlier.
Yeah, we did. Hey, I'm Sam Keller.
Nice to meet you.
Nice to meet you as well. And your name?
Joshua Hodge.
Joshua. Okay, nice to see you, Joshua.
If y'all wouldn't mind a little, input on that when y'all were talking about the creation of the documents and stuff. That's not really what the act says, about, like, you don't have to provide a document that doesn't exist, it says record. And so I was, like, document would be a reasonable interpretation of that. There wasn't also a section that says electronic, keeping a record should not limit public access to them. So I would say that the record is anything that exists within a database. And so creating the report is not creating a new record, it's just providing public access to that record that already exists in the database.
Well, sometimes it's a database and sometimes it's something else, so it just depends on what kind of record.
Yeah, and I'm
you're
not
talking
familiar
about.
with the details of that, and just something to consider.
Appreciate you
I think
sharing that with us.
I believe the courts probably agree with that interpretation. Mr. Chairman, I would need to speak with you about instructing the minutes from this meeting.
Yeah, which ones do you want?
Just the most recent, like, year or something would be fine.
Okay. Tammy, where are the minute books for the last year?
You do, buddy.
Can you get them and bring them
Oh,
to
we
the
just
front
want
line? Yeah, we'll get those for you.
I appreciate it. You get these, Tim?
Let me make sure that it's the signature.
He left it on my desk.
Okay, thank you.
Can I introduce myself to you, Josh Hodge?
I'm Tammy, it's nice to meet you.
Thank you.
I'm the one that struggled with a computer someday.
Yeah.
It's like today,
You have-
it's
you have,
like what
uh,
happened to my pages.
You have a lot of stuff on your plate during the meeting.
Well, yeah, it's. Try not to let it